So today we'll be talking about a case law which serves as a very important case. So when a law student enters a law college, their faculty is allowed to be anyone, maybe asking about Kesavananda Bharati case. This is the longest case ever recorded and it took 68 days in which more than 100 cases were cited. And in order to know what was right and what was wrong, it compared more than 70 constitutions around the world. Do you know how many pages the judgment was? 703 pages. This is the most important case in which it is called as Kesavananda Bharati was state of Kerala. Now let's look onto the facts of this case. So Kesavananda Bharati was a chief pontiff in the Ednade Mutt, a monastic religious institution located in Kasaragod district, Kerala. So Bharti had some land in the Mutt which he owned, and the state Kerala government passed the Land Reforms Amendment Act in 1969. So, as per this act, the government could acquire some of the lands that belonged to the Mutt. So, in March 1970s, Bharti moved to the Supreme Court to enforce the right that was guaranteed to him, which can be stated as Article 25, the right to practice and propagate religion. Article 26, right to manage religious affairs. Article 14, right to equality. Article 19, 1F, freedom to acquire property. And Article 31, compulsory acquisition of property. The Kerala state government enacted another law, the Kerala Land Reforms Act 1971, even as the petitioner was under the court's consideration. The contention made by the petitioners brought to the fore the validity of various amendments that were brought in by the Parliament to nullify the effects of Golknath was the state of Punjab. The petitioners challenged in particular three constitutional amendments: 24th Amendment, 25th Amendment, and 29th Amendment and their validity. The issues raised before the court were whether the following are constitutionally valid, that is, 24th Constitutional Amendment 1971, 25th Constitutional Amendment 1972, the extent to which the Parliament can exercise its power to amend the Constitution. The question underlying the case also included: was the power of Parliament to amend the Constitution unlimited? In other words, could Parliament order, amend, or abrogate any part of the Constitution, even to the extent of taking away all the fundamental rights? The landmark judgment was delivered on 24th April 1973 by a razor thin majority of 706, wherein the majority held that any provision of the Indian Constitution can be amended by the Parliament in order to fulfill its socio-economic obligation that we guarantee to the citizen as a given in the preamble, provided that such amendment did not change the Constitution's basic structure. The minority, however, in their dissenting opinion, were wary of giving the Parliament unlimited amending power. The court held that 24th Constitutional Amendment was entirely valid, but it found the first part of the 25th Constitutional Amendment to be intra-virus and the second part of the same ultra-virus. To conclude, the case of Keshwanda Bharti with the state of Kerala, as mentioned before, had been heard for 68 days, the argument commencing from October 31st, 1972 and ending on March 23, 1973. The hard work and scholarship that had gone into the preparation of this case were breathtaking. So literally hundreds of cases had been cited, and then the Attorney General had made a comparative chart analyzing the provisions of the constitution of 71 different countries. The majority of the bench wished to safeguard the constitution by preserving its basic features. The judgment was based on sound reasoning, and then it was given after careful analysis of the multifarious aspects. The bench opined that the Parliament were to get unfettered power to amend, there were chances of the power to be misused, and the government could charge it as per their own preference and whims. Such limitless power vested in the hands of the government could mean that the basic features and also very essence of the spirit of the Indian constitution could be changed. There was a need of a doctrine which could protect the rights of both the Indian Parliament and the Indian citizen. The bench met the need halfway and came up with a basic structured doctrine that protects the right of both camps. It is to be noted that while in the US only 27 amendments has been made, India has seen over 100 amendments since independence. Noted that while in the US only 27 amendments was made, India has seen over 100 amendments since independence. So despite this big number, the spirit of constitution and also the ideas of the constitution makers have not been tampered with. It is because of the bench decision that the identity and the spirit of the Constitution have not been lost. So, this landmark case has given a Constitution stability. So, even though the petitioner lost this case partially, the Supreme Court ruling in the Kesavananda Bharati case turned out to be a savior for the Indian democracy and also prevented the Constitution from losing its spirit.